Welcome. Yes, we're live. Hi. I know I'm 1 minute late. So sorry. My computer a couple minutes off. So little technology glitch. Welcome everyone. Hi. Hello. Welcome. Thank you for being here. I'm super excited. Well, I don't know about excited. That's probably not the right word. I'm excited to bring some knowledge and maybe a little bit of clarity to what's going on. I'm hoping this is actually going to be a pretty quick live stream though, because I'm not going to be giving you like a constitutional law scholars deep dive into this. Like, we're not here for that. I am here to give you an overview over the two SCOTUS rulings that came down last week about vaccine mandates, what they mean, what happened, why they were seemingly contradictory, and what legal scholars I've seen are saying about it, because I think it says a lot about the state of the court right now. So if you're here for an overview, you've come to the right place, my friends. Welcome. Thank you for being here. So glad you were able to join, okay? So let's do this. We got some heavy legal topics to talk about. Not heavy, but like mentally a little exhausting. So let's get into it. Okay. Last week, the Supreme Court of the United States issued two rulings, one upholding a vaccine mandate and one saying a vaccine mandate was invalid. These rulings have had SCOTUS scholars up in arms. Let's talk about what this all means for us and for the court. If you're new here, my name is 𝗬𝗦𝗣𝗦𝗢. I'm a real-life lawyer on a mission to demystify the law and how it affects your everyday life. That being said, I may be a lawyer, but I'm not your lawyer. Nothing that I say should ever be construed as legal advice, and you should always seek the advice of a licensed attorney before making any legal decisions, all right? I'll take your questions at the end because I want to get through this at a clip because I respect your time, okay? So save your questions for the end and I'll take a look at the chat and see if I can answer them. Again, these are some heavy legal topics, so I'm not an expert on this. I'm just telling you what I've read experts are saying and what I read in the opinions, which I believe I linked below. If not, I'll throw them in the chat later. Can't remember. Okay, so first case, National Federation of Independent Business versus Department of Labor. I'm going to be calling that the NFIB case because that's a lot of words, okay? If you'll remember, OSHA announced back in November a nationwide vaccine mandate. That's what it's being called, at least, a vaccine mandate, but it was not. It was a vax or mask mandate that said either you have to vax or you have to mask and test weekly. So calling it a vaccine mandate is a bit inaccurate, okay? And that this mandate covered the vast majority of employers with greater than 100 employees. Basically, if you have over 100 employees, they have to get vaccinated or wear masks and get weekly testing, the mandate said, or the employer would be at risk for being cited for OSHA violations. OSHA's reasoning behind this was that contracting COVID is a workplace hazard, and as such, OSHA has the authority to regulate in that area. The mandate affected an estimated 84 million Americans. Obviously, employers, a lot of them, weren't super happy about this because it could mean having to fire or lay off workers. Workers didn't want this. Business people, especially on the right of the political spectrum, don't want government in their business. So there are a bunch of lawsuits that came out of this. And originally, the Fifth Circuit ordered a stay, meaning that the rule wouldn't be enforced until the lawsuits made their way through the courts and a determination as to the enforceability of the law was determined. But then a different judge in the Sixth Circuit lifted the stay after OSHA appealed that decision. So because there's a circuit split, there's a lot of contestation around this issue, it went to the Supreme Court. So what happened is the Supreme Court granted a lift of the stay on the ruling. But SCOTUS granted the lifting of this stay based on the fact that they thought if the pending litigation were allowed to run its course, that the plaintiffs, the ones challenging the mandate, would succeed on the merits. Basically meaning that the current pending litigation only has one outcome at this point because SCOTUS basically gave a preview of how they would rule if the cases progressed to them on the merits. So lifting the stay effectively gave the stamp of disapproval from SCOTUS as to this mandate. Okay, so what did SCOTUS say? Well, basically, they really focused on the occupational aspect of OSHA's authority, saying that OSHA has authority to regulate the health of workers in their place of employment. And when an administrative body like OSHA makes a regulation like this, Typically, they have to allow for a notice and comment period. They give notice to the general public about this regulation, and then they have an open comment period during which the people affected by the proposed regulation can give their input. This is required unless there is an emergency situation, in which case there's an exception where OSHA can make an emergency ruling that doesn't have to go through the full notice and comment period, and that's what happened here. According to the ruling, though, that SCOTUS made, this power has only been used by OSHA 9 times, this emergency power, 5 of which were overruled in court. So what the Supreme Court took issue with was the broadness of this OSHA mandate, which did not delineate based on industry or risk factors. They said that the level of sweeping ruling it holds a vast economic and political significance that requires congressional approval. This is what's known as the major questions doctrine, this idea that when an agency makes a ruling that holds a vast economic and political significance, then it's going to need a congressional approval. This is a doctrine, this major questions doctrine, that was created by SCOTUS precedent, which says that strict limits need to be placed on a federal agency's ability to exercise powers of vast economic and political significance. And here they say that this is vastly significant because it affects 84 million Americans, all right? Quick aside, this case is deep into administrative law, which is widely known to be one of the harder classes in law school. I took it and can confirm, all right? Basically, admin law is considered the unofficial 4th branch of government because so many rules and regulations that control how we live every day are promulgated by agencies and administrative bodies like OSHA. These administrative bodies are created via statute written by Congress. And because of the power delegated to these admin bodies, administrative bodies, we want to make sure that power isn't abused by making sure that they're doing what Congress actually wanted them to do when Congress created the administrative body. Because, they say, Congress is the voice of the people, theoretically. So SCOTUS is very concerned with the type of power Congress intended to give to OSHA and whether OSHA overstepped that power in making this mandate. And the Supreme Court says, yes, it did. It overstepped the power. Because they said that this does not count as a workplace hazard, COVID, because COVID can spread literally anywhere. It's not specific to employment and the workplace. And OSHA's sweeping regulation does not regulate specific workplaces where COVID contraction is riskier due to like cramped conditions or working directly with the virus, for example, but instead regulates all workplaces. They say that allowing OSHA to make this sweeping ruling could open the door for them to start regulating against other common day-to-day dangers that everyone faces just by virtue of like being a human that exists on this planet. Okay, so that's the basics of this NFIB, National Federation of Independent Business versus Department of Labor in a nutshell. The Supreme Court said it was overbroad and outside the scope of OSHA's authority. Okay, so on that same day, January 13th, they also announced their ruling in a case called Biden v. Missouri. In that case, the Secretary of Health and Human Services, through CMS, Centers for Medicaid and Medicaid Services, Medicare and Medicaid Services, announced that in order for facilities that receive Medicaid and Medicare benefits and funding, in order for them to continue to receive such funding, they would need to ensure that their staff is vaccinated against COVID. A couple district courts, again, lawsuits come flying in, a couple district courts enjoined enforcement of the rule pending that litigation, and the federal government, through Biden's name, appealed that ruling, and SCOTUS ended up making a ruling siding with Biden, with the Biden administration, in this case, saying that the regulation enforcing the vaccine is appropriate and can be enforced. So the facilities that receive Medicare and Medicaid funding are healthcare providers like hospitals and nursing homes, and CMS has the authority to promulgate rules to ensure the health and safety of individuals being cared for by facilities that receive this government funding. CMS already has a super long list of requirements for facilities receiving Medicare and Medicaid, and healthcare generally, especially the healthcare that receives government funding, which is a large portion of it, is one of the most highly regulated industries in the United States. So regulating the healthcare industry, not a shocking move in any capacity. Someone's muffler is going out, if you can hear that. Basically, the idea is that the secretary has the authority to control these facilities because they are receiving government funding. Because government money isn't a no strings attached situation ever. Once a facility starts receiving government funding, they're beholden to basically whatever regulations the government wants to impose as a string attached to that money. And generally, the government has pretty wide authority to regulate those funds however they see fit within the confines of the statute that gave them the authority to begin with. Okay, so here CMS is using its congressionally given power to regulate the health and safety of patients in government-funded programs by requiring that employees be vaccinated. So again, a broad vaccine mandate for employers via the NFIB case, not good. But a broad vaccine mandate for recipients of Medicare and Medicaid funding, fine. And the court reasoned that, if you go into a Medicare facility and you are working there and you have COVID and you spread that, then that is against the regulations promulgated by CMS. Okay, so in a nutshell, the difference between these two cases is that one involved a sweeping regulation for all private businesses and over 100 employees, and the other involved a narrow regulation specifically for healthcare facilities receiving federal funding. But breaking it down into that kind of really basic difference kind of overlooks some logical fallacies that a lot of SCOTUS scholars are pointing out. There's some insufficiencies in the court's legal reasoning in these cases, which is a trend that seems to be a growing issue in this conservative court, a general lack of concern for judicial precedent or like any logical reasoning to back up their rulings. Okay, so here's what scholars are saying. First, as to the major questions doctrine, remember the one where the court says that the federal agencies should be really limited in their ability to exercise powers of vast economic and political significance? They say in the NFIB case, the Supreme Court says that 84 million Americans will be affected or could be affected. But they don't cite to this issue in the Medicare-Medicaid case. And the regulation in that case could affect upwards of 10 million Americans, virtually all healthcare facilities. So it's unclear where the cutoff is when it comes to the definition of what is a vast economic and politically significant ruling by an administrative body. Why does it apply in NFIB and not in Biden v. Missouri? They don't give us a reason. They don't even mention it in the Medicare-Medicaid case, a case that is decided on the very same day. All right. Second, the court in NFIB is very concerned with OSHA only regulating dangers that occur in the workplace, and COVID can happen anywhere. But it doesn't address the fact that there are many things OSHA regulates that exists everywhere all the time, like the risk of fire and faulty electrical installations, for example. The court says that unlike those issues, though, the vaccine can't be undone at the end of the workday. Like, you have to wear fire safety equipment, but you can take it off at the end of the workday. Your COVID vaccine can't take it off at the end of the workday, okay? But the vaccination of healthcare workers in that Medicare-Medicaid case also can't be undone at the end of their workdays, and they don't mention that in the CMS case. So what's the difference? Also, as an aside, this is all coming down while the Supreme Court of the United States requires people arguing before them to get tested for COVID so that the justices don't get sick while on the job. Not to mention that the team of lawyers that was arguing against vaccine mandates had to do so remotely because they contracted COVID. On top of that, Neil Gorsuch refuses to wear a mask, which is people think is what causes Justice Sotomayor, who has diabetes, to appear remotely from her chambers instead of appearing in person in oral arguments, because she sits right next to him and is like at risk, and he's like, nope, no mask. The cognitive dissonance is truly astounding. Also, the same conservative justices that are like, abortion isn't in the text of the Constitution, so Roe v. Wade isn't valid, are also the ones that are like, we're going to adopt this judge-made major questions doctrine willy-nilly, even though it's not in the Constitution or any statute ever written by Congress. Okay? Not to mention the fact that there is precedent for OSHA regulating biological health concerns that exist both inside and outside the workplace. For example, they have been concerned with bloodborne pathogens since 1989 during the height of the AIDS epidemic. And during that period, they were met with strong congressional approval. Or there's the Workers' Family Protection Act, which Congress passed to give OSHA the right to issue rulings related to hazardous chemicals and substances, including infectious agents, that can be transferred from the workplace to a worker's home and family. There's also precedent that is well established in which the court, when it's unable to come with a principled reason for differentiating between what counts as a good rule or a bad rule, so like, if there's something vague in the statute and they can't tell whether or not what the administrative body did jives with the statute, there is a doctrine that is well established called the chevron deference, which gives strong deference to federal agencies because we don't want to allow the court, an unelected body of judges, to be drawing lines in the sand. Okay? The reasoning being that the people working at an agency like OSHA generally have subject matter expertise in the areas they're regulating, and the court, again, made up of a bunch of random judges with varying levels of expertise and backgrounds, they don't have that expertise. However, in this case, chevron deference, not even mentioned in either of these. No deference was given at all. And of course, the court did grant some concessions that the Biden administration can issue some more limited and targeted mandates. Supreme Court scholars are concerned with the selective application of the major questions doctrine. Again, it's a doctrine created by judges. It's vague and it can be selectively applied. It's not approved by Congress, and it shows up nowhere in the Constitution. Of course, creation of judge-made rules is important for interpreting things like the Constitution, but it also allows for things like what happened last week, where we get two different rulings by the same court that seem directly at odds with each other. As one legal scholar pointed out, it appears as though the court made the decision for how it wanted each case to come down and then worked backwards to build a legal reason from there, as opposed to following legal reason to a logical conclusion. So effectively what the court is doing is giving lip service to the idea that this should be up to Congress or the states to do vaccine mandates, but then instead just taking the power into their own hands to rather arbitrarily delineate what the Biden administration can and can't do when it comes to COVID. On top of that, their reasoning in the OSHA case, in part, relied on the fact that OSHA has never been allowed to issue such sweeping regulations. However, this is an unprecedented issue in the history of OSHA. There has never been anything like this for OSHA to regulate. So that in itself is a logical fallacy. But many justices are trying to say that this should be up to Congress or the states, but instead they are making this decision on their own in a way that a lot of legal scholars are feeling like the court is starting to go a little bit rogue. And that's the tea, my friends. All right? I know that was a lot of information that I just flew through, but that's the basic background of this case. Lay your questions on me. Like I said, I am not an expert in this area, but I am interested in it, and I think that it's important to understand this is an example of the ways in which the court is straying from legal reasoning or precedent, I guess you could say. And it's a signal of what's been happening and what's to come. So let's take a look at the chat. Let me lean over here. Tell me your thoughts. What were the votes on both cases? One was 5-4, and the other was, oh gosh, I didn't memorize this. And the other one was 6-3, I believe. But I did not memorize that. It was split ideologically for much of that. Let me see. What do we got here? Thank you, 𝗦𝗫𝗥𝗩𝗏𝗧, for the super sticker. It's two, so is it basically two different opinions on the same type of case law? It's related enough, it's administrative law, that the fact that they willy-nilly cited one doctrine in one case and then kind of overlooked it in the other case is, I think, what is concerning here. Yeah, let's see. How do I fight back against court rulings at a Supreme Court level in cases of rogue court energy? Oh my God. Hashtag rogue court energy. That's excellent. That's the thing. Here's the tea. This is the problem with the Supreme Court generally, is that we're giving these unelected officials lifetime tenure in these positions. I mean, this harkens back to like FDR's court packing threats, trying to like change the composition of the court because it's such a permanent thing. This is why it was so devastating when RBG died, because, and during like the Kavanaugh hearings, if you'll remember, that was a traumatic moment, frankly. because like anyone with any knowledge of the courts knew how permanent this was going to be. Right. What are your feelings on Biden packing the courts or term limits? I mean, definitely term limits. I think I'm I'm not a constitutional law scholar, so I don't know the full extent of the ramifications of court term limits in the Supreme Court, but I can't imagine that it's a bad idea because the Supreme Court was created in the 1700s when life expectancy was like 60 if you're lucky, and now we got justices in their 80s making decisions. So I think a term limit makes sense. As far as packing the courts, the thing that is frustrating to me about our political process right now is that anything that we try to do, we being the Democrats, I guess, anything that the Democrats are going to try to do, Republicans are going to be able to come back and say, well, you tried to do that, so now we can do it, or vice versa, because they're shameless. And so it makes me a little nervous because if he does it, then who's going to do it in the future? You know what I mean? Because I don't feel confident that we will have a Democratic president after 2024. Could I do a video on court circuits? Yeah, I should do some more videos on like some more basic background of like how the judicial system works, because yeah, it's not something I remember. Like one of my first assignment in law school was explaining that, because we probably learn it at some point in history class or something, but it doesn't solidify in your brain until you see it in action. Was Roe v. Wade overturned? No, it was not. But we are waiting on a decision to come down from the court that could severely limit it. But we're still waiting to hear on that ruling. Wow, I'm exhausted, my friends. Are any justices close to being dead or leaving office? How can we balance the scales here? There is one, oh my gosh. I'm not great with names and memorizing factoids, but one of them, people are calling for him to retire because there's the criticism of RBG that she should have retired during an Obama presidency so that he could have replaced her. But that hindsight's 2020 in situations like this, so it's kind of hard to say like it's your moral duty to retire now while we have a Democrat in office, because you never know. You never know. I love your channel, but I hate that you make it political. I'm not sorry. It's what we do here, and if you're afraid of talking about politics, then this is not the space for you. And I'm extremely left-leaning, and if you're not okay with that, like, I'm totally chill with hanging out with people with different beliefs, but if you can't handle that, then Breyer's the guy, thank you. Yeah, the law is inherently political. There is no such thing as an unbiased attorney or judge. Bias is everywhere, and I'm never gonna say that I am not biased. And I never said that I'm not biased, so. Oh, gosh. Are there any other pending rulings? I actually did a video on Supreme Court cases to look out for this term, which would be helpful with that. Really, the one that I'm most concerned about is the Roe v. Wade one. It's Mississippi, I think, is one of the parties, or Missouri. So sorry, again, factoids, not great. But that's the one that I'm most concerned about. I'm sure there are other ones that are coming down, but again, I'm not a SCOTUS scholar. I follow many on Twitter, though. If you want to follow SCOTUS scholars, follow them on Twitter. There's a bunch of them. Leah Littman is one that comes to mind. She hosts, or is one of the hosts of a podcast called Strict Scrutiny, which I highly recommend if you are interested in getting really deep and nerdy into Supreme Court rulings and law and precedent and everything. There's a lot of legalese in it, because I think it's made for lawyers, but I think they do a really good job of breaking down these cases in a really detailed way. Mississippi, thank you. I know. Moira is not here right now because we have a guest staying, and there's another dog, and she's been a little on edge, and so she's having a nice quiet time with a little treat in another part of the house, because I knew she'd be like barking and panting and a lot. So I'm so sorry I don't have Moira Cam right now, but I'm giving her some quiet, calming time. Why does SCOTUS have to be such a gross looking word? Great question. Man. Who knows? I didn't say anything particularly biased, just that term limits should be a thing. Yeah. And I'm never going to say I'm not biased, though. So if you're looking for something, I was going to say, if you're looking for unbiased anything, go to the news. But even that, everyone has bias. And I think it's more dangerous when someone claims that they don't have bias than when they identify their biases. You know what I mean? All right. Thank you for being here. I did a video on the Holmes verdict already. Check from like a week or two ago. Yeah, I'm exhausted. I haven't had dinner yet, so I'm gonna end it there. 25 minutes. What am I, a professional? Thank you. The glasses are from Warby Parker. A lot of people have asked. Glasses from Warby Parker. I believe they're the Blair frame. And reminder, my newest video drops Wednesday. I'm doing a part 2 to my reaction to with Trixie and Katya. That drops Wednesday. You can access it now early if you join this channel by clicking the little join button or over on my Patreon as well. Thank you so much, Pearface, for the little super chat. I very much appreciate the support. And thank you for being here. I hope that everyone has a great night. You can continue to leave questions in the comments below and I'll check them and answer where I can. And I appreciate your support as always, and I will see you around the internets, okay?